Hi everyone, welcome back to Inain's Forensic Classroom. So in this channel, we have explored what evidence is, the different types of evidence and how they work in investigation. So today we are moving one step further. We are going to talk about how evidence becomes admissible in court. Because knowing what kinds of evidence exist is one thing, but getting it admitted in a legal proceeding is a whole different challenge. A perfectly collected fingerprint, or if you have a solid digital record, it would mean nothing if it is not admissible before a judge. So in this video, we will understand what admissibility means, what conditions evidence must meet, and why it is the foundation of every fair trial. So let's talk about admissibility of evidence in today's video. So let's start with the basics. What is admissibility? So admissibility basically means whether a piece of evidence can be legally accepted in a court or not, and how it is accepted or considered by the court while deciding a case. So if an item of evidence isn't admissible, it may be ignored or it may be given very little weight, even if it seems relevant to you. Now, so if evidence is not admissible, the judges cannot rely on it, no matter how interesting or logical it looks to you. So admissibility basically act like a filter. So only those pieces of evidence that meet the legal standards are allowed to pass through and influence the verdict. Now, under the old Evidence Act, that is Indian Evidence Act of 1872, Section 136 clearly said that the judges decide whether evidence is admissible or not. And the same principle continues in Bharatiya Sakshya Adhiniyam Act of 2023. So the judge basically act like a gatekeeper. So judges decide whether the evidence is admissible or not. They only allow legally sound and relevant evidence to get in. Moving ahead, let's look at the conditions for admissibility. So let's look at the main conditions that decide whether an evidence is admissible or not. The first one is relevance. So first and foremost, evidence must be relevant. So that means that it should relate directly to the facts in issue, which basically means that the actual disputed facts in the case, or relevant facts. Relevant facts is those facts that help prove or disprove something important. So example, if the case is about a robbery, now you have found the accused fingerprints on a door. So these fingerprints are relevant. But if I tell you that it is a fact that accused like action movies, this is also a fact, but it is not relevant to the case. This is totally irrelevant. So in the section 3 to 50 of BSA, it deals with what counts as relevant facts. If something is irrelevant, it is out even before it reaches the judge. The second condition is proper form and collection. So see, even if evidence is relevant, it must be collected legally and properly. If it is obtained through an illegal search, or if there is some violation of rights or tampering, it can be rejected. For example, if police seizes a phone without a warrant and then they extract messages without permission, that digital data might be excluded. So courts strongly value the integrity of how evidence is collected. Forensic experts, investigators, and police officers, they all must follow standard operating procedures. Otherwise, even stronger evidence can collapse. Moving to the third condition, which is authentication. Authentication is basically genuineness. The evidence must be authentic. It must be proved that the evidence is what it claims to be. For example, if someone submits an email as an evidence, so they must prove that it really came from the accused email address and it wasn't altered. So under BSA, section 61 to 63, this rule applies strongly to digital and electronic evidence, and it would require a certificate of authenticity. Then the fourth condition is chain of custody. So chain of custody is very important in forensic science. For your physical evidences or digital devices, courts require documentation of the entire trail, where it was collected, who handled it, how it was stored, and how it reached the court. Now, for example, if I tell you we have a blood sample and it is collected at a crime scene. Okay, so the court must know who sealed it, who has transported it to the lab, who have analyzed it, and how it was stored. So if this chain breaks, means that if there is a gap in the documentation, the defense can claim that the sample was tampered with or mixed up. So it would make the evidence inadmissible. A broken chain of custody can cast serious doubt on its reliability. Then we have fifth condition, which is legal and statutory compliance. So even if the evidence is relevant and it is collected in the right way, it can still be rejected in the court if it doesn't follow certain legal rules. For example, if the evidence is unfair or misleading, or it might confuse the judge or jury, the court can decide not to accept it. For example, if it is hearsay, like something someone else has said, not what the witness has personally saw or heard, so it is not admissible unless it fits into a specific legal exception like a dying declaration. So if it violates confidentiality or privilege, like a private conversation between a lawyer or a client, it cannot be used as an evidence. Or if it doesn't follow the proper legal format or procedure, like if there is a missing required certificate or not recording a confession correctly, the court can reduce its importance or it can reject it completely. Now, the admissibility of digital and electronic evidence is one of the biggest changes under the Bharatiya Sakshya Adhiniyam, and it is the clear recognition of electronic and digital evidence. So your WhatsApp chat, GPS log, CCTV footage, mobile data, all now have a clear admissibility pathway. So for forensic and investigation professionals, you must secure metadata, document how the device was handled, authenticate backups, and provide a certificate. Because, you know, in today's world where crimes are digital, even if the evidence isn't admissible, a whole case can collapse. So to sum it up, admissibility of evidence ensures that only reliable, relevant, and lawfully obtained evidence becomes a part of the trial. So in the next video, we will talk about something closely related, expert testimony, where we will discuss how forensic experts present their evidence in court and how the courts test their reliability using standards like Daubert standard and the Fry standard. So don't forget to like, share, and subscribe to Inain's Forensic Classroom for more such forensic content. See you in the next video. Bye.